Hello and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we update you with the latest legal developments across the country. Starting with the headlines. Supreme Court to deliberate on Uddhav Thackeray's plea, challenging Speaker's order, declaring Eknath faction as real Shiv Sena. Supreme Court reserves order on Tejashwi Yadav's plea for transfer of defamation case. Delhi High Court denies 20-year-old unmarried woman's plea to terminate 28-week pregnancy. Delhi Court rules on Muslim adoption. General rule prevails over Shariat Act. Now the headlines in detail. In a significant development today, the Supreme Court has agreed to examine the plea filed by Uddhav Thackeray faction of the Shiv Sena party, challenging the order of Maharashtra Assembly Speaker Rahul Narvekar. The dispute stems from the declaration made by the Speaker on January 10th, terming the Eknath faction of Shiv Sena as the real political party, following a split within the party in June 2022. A bench led by the Chief Justice of India D.Y. Chandrachud, along with Justice J.B. Pardiwala and Justice Manoj Mishra, took cognizance of the matter during the hearing. Earlier on January 22nd, notices were issued to Chief Minister Eknath and other legislators associated with his bloc of Shiv Sena. The court had then directed the listing of the matter after 2 weeks. However, the top court was informed today by senior advocate Kapil Sibbal, representing the Uddhav Thackeray faction, that the scheduled listing of the plea on Monday had not occurred. The CJI in this regard assured the counsel and said, "We will see it." The core contention put forth by Thackeray faction is that the Shinde faction has unconstitutionally usurped the power and that the presiding government is unconstitutional. The Supreme Court today reserved its order on a plea filed by the leader of Rashtriya Janata Dal, Tejashwi Yadav, seeking the transfer of a criminal defamation case against him in an Ahmedabad court. The case, registered under Section 499 and 500 of the Indian Penal Code, revolves around his alleged statement, "Only Gujaratis can be thugs." Yadav requested the transfer of the case to a location outside Gujarat, preferably Delhi. A bench of Justice Abhay S. Oka and Justice Ujjal Bhuyan took note of a recent apology tendered by Yadav. The court remarked, "We will pass orders," indicating that a decision will be made in due course. Earlier on January 29th, the top court directed Yadav to file a proper statement withdrawing his controversial remark. Responding to this, Yadav submitted an affidavit on January 19th, officially withdrawing his statement. During the hearings, the Apex Court temporarily halted the proceedings in the criminal defamation complaint and issued notice to the petitioner, a resident of Gujarat, who initiated the legal action against Yadav. The Delhi High Court has refused to grant permission for the termination of a 28-week pregnancy to a 20-year-old unmarried woman. Justice Subramaniam Prasad delivered the verdict, asserting that feticide cannot be permitted. The court emphasized that no abnormalities were noted in the medical reports and expressed orally that abortion of a completely viable fetus at 28 weeks would not be permitted. The woman claimed that her pregnancy resulted from a consensual relationship, but she only became aware of it on January 25th and sought an abortion after the legally permissible 24 weeks gestation period because of her unmarried status. The counsel for the woman told the court that her family was unaware of her condition, urging the court to consider her circumstances. However, the court rejected her petition, terming the abortion at this stage as feticide. In a recent development, a Delhi court has delivered a significant ruling on adoption within the Muslim community, particularly in the context of a partition suit. The court in the instant case dismissed a partition suit related to the property of a deceased Muslim man, Zamir Ahmed. The suit filed by Zamir's brother sought a share in the property, interestingly because Zamir and his wife had no biological children. The petitioner claimed that though they adopted a son, it was done without making a declaration under the Muslim personal law. Additional Sessions Judge Praveen Singh, presiding over the case, ruled that such adoptions will be governed by the general law of the land rather than the Muslim personal law, and the adopted child will be considered the legitimate child of the adoptive parents. The court emphasized that even without filing a declaration under Section 3 of the Shariat Act, Muslims have the right to adopt a child, and such child shall be entitled to the same rights, privileges and responsibilities as a biological child. The court also relied on previous judgments of the Supreme Court and clarified that Muslims who have not filed a declaration under Section 3 of the Shariat Act will not be subject to Muslim personal law regarding adoption, wills and legacies. Consequently, the widow and the adopted son of Zamir Ahmed were acknowledged as the legal heirs, while the claim of the brothers and sisters of the deceased for a partition was rejected. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.